Welcome to today's webinar, the Employment Rights Bill, Key Aspects and Practical Preparation. My name is Leslie Rennie and I'm one of the practice development lawyers in Brodie's Employment and Immigration team. I'm joined by my colleague, Louise Usher, Senior Associate. Thank you. We'll begin today's session with a brief history of the Employment Rights Bill and an update on its progress. The Employment Rights Bill represents the most significant employment law reform in decades. As such, it has been subject to close parliamentary scrutiny, which began on the 10th of October last year when it had its first reading in the House of Commons. It then moved to the House of Lords in March 2025. The House of Lords added several non-government backed amendments to the bill, including a right to request guaranteed hours offers as opposed to a right to receive a guaranteed hours offer. And Louise will touch on that further on in the presentation. A 6-month qualifying period for unfair dismissal as opposed to day one unfair dismissal rights. A reinstatement of the existing 50% turnout threshold for a ballot on industrial action, and reinstating the existing position that new members of a trade union need only contribute to the trade union's political fund if they opt in to doing so. This triggered a ping pong between the houses, a back and forth exchange of the bill as the houses try and agree on the final wording of it. Somewhat unsurprisingly, the House of Commons rejected the Lords' amendments on the 15th of September this year. The bill returned to the House of Lords on the 28th of October this year, who insisted upon some of their amendments, including in relation to a 6-month qualifying period for unfair dismissal and the retention of the turnout threshold for industrial action and contributions to trade union political funds. On guaranteed hours offers, they suggested a compromise position that would have required employers to write to workers at the end of each reference period, with workers having the option to opt out of receiving such notifications with the ability to opt back in at a later date. The ping pong continued. Yesterday, the House of Commons considered the Lords' amendments and rejected these, but did appear to propose some amendments in lieu. In relation to unfair dismissal, the government has insisted upon day one unfair dismissal rights. However, an amendment was proposed to oblige the Secretary of State to consult prior to making secondary legislation on the initial period of employment. More on that later, including the length of this and any compensation limit to apply during it. As consultation had already been promised, this is not a significant amendment. In relation to the removal of the 50% turnout threshold for a valid ballot on industrial action, an amendment was proposed to require the Secretary of State, when deciding whether and when to make regulations to implement the removal of the turnout threshold, to consider the impact any provision made after the bill is passed for industrial action ballots to be conducted otherwise than by post has had or is expected to have on the proportion of those eligible to vote actually voting in such ballots. Essentially, a consideration of the impact of e-balloting. In relation to contributions to a trade union's political fund by its members, the House of Commons maintained its position that the requirement that a member should be opted out unless they opt in should be removed, and made a technical amendment around the process of opting out. The bill, as amended by the Commons, will now return to the Lords on a date yet to be announced. The Lords can then either bow to convention and accept the Commons amendments, in which case the bill will pass, or continue to insist upon their disagreement, in which case the ping pong continues until such time as the Houses reach an agreement or a complete impasse is reached. I'll now hand you over to Louise. Next slide, please.
Thanks, Leslie. So as Leslie mentioned, the employment law landscape is going to change fundamentally as a result of the ERB. We're going to see changes in relation to unfair dismissal, contracts and working practices, trade unions and collective bargaining, families and flexible working, sexual harassment and harassment more generally, fire and rehire, and collective redundancies. So, as HR professionals, pretty much everything that you could think of. Um, Next slide, please. So, given the extent of the reforms, a phased approach to implementation is being adopted over the next 2 years, and April and October are going to be the kind of key anchor points, which is when we typically tend to see employment law changes come into force in the UK. The staged approach is being taken in order to give businesses adequate time to prepare, because the government's narrative is that the ERB can and should work for employers in the same way as it will work for workers. An indicative roadmap was published in July this year, and that contained details of various consultations that the government intends to run in order to shape some of the new provisions. So, in many cases, the ERB contains the high level principles, but a lot of the detail is actually going to be fleshed out in secondary legislation, and we haven't seen a lot of the detail of that yet. I'll talk about some of the reforms that are coming into effect most immediately at the time that the bill is passed, but I wanted to just take a quick bird's eye view of some of the other changes that are coming down the track later on. So, a big chunk of the reforms are going to come into effect in April 2026. So we're looking at that point, the maximum protective award for collective redundancies doubling from 90 days gross pay per affected employee to 180 days gross pay. So if as an employer you fail to collectively consult with appropriate representatives in a situation where you're making 20 or more employees at the same establishment redundant within 90 days, then the penalty for that is going to be increasing really quite substantially. Paternity leave and unpaid parental leave will also become day one rights. So at the moment, there's qualifying service requirements that apply. Those are going. Sexual harassment disclosures will be protected under the whistleblowing framework, provided that the person making the complaint reasonably believes that the disclosure is being made in the public interest. So that will then mean that workers who are making those disclosures will be protected from detriment and from dismissal as a result of having made those disclosures. There isn't any qualifying minimum period of service, and awards will be uncapped. There's also, I think, other potential consequences of that change, such as sexual harassment disclosures being excluded from confidentiality provisions and settlement agreements. And there's also a possibility that interim relief can be awarded in circumstances where it is likely that an employee has been dismissed because they've made a protected disclosure relating to sexual harassment. And so that could result in an employer having to continue to pay an employee until resolution of their complaint in the employment tribunal after dismissal. There's going to be a new state enforcement body called the Fair Work Agency, and that's essentially an amalgamation of agencies that already exist. So the Employment Agency Standards Inspectorate, the Gangsters and Labour Abuse Authority, HMRC's National Minimum Wage Enforcement Team, and this agency is essentially going to have a broad range of enforcement powers for things such as levying financial penalties on employers that don't pay employment tribunal awards. They'll also have the power to require individuals to provide information and to enter business premises in order to get documents, but it's not yet known when those powers will come into force. There's going to be major changes to statutory sick pay. So lower earnings limits will be removed, and statutory sick pay will be payable from day one of incapacity for work instead of day 3 as it is at the moment. And then there's going to be simplification of the union recognition process for trade unions and introduction of electronic balloting as well. In October 2026, we'll see the introduction of the prohibition on fire and rehire other than in very narrowly defined circumstances, which I'll come back to. The preventative duty to prevent sexual harassment in the workplace is going to be extended so that employers have a duty to take all reasonable steps to prevent harassment. At the moment, it's reasonable steps, but we're changing to all reasonable steps. So it's increasing the bar for compliance for employers. Employers will become liable for third-party harassment. So an employer will be liable if a third party, such as a customer or a client, harasses an employee who is operating in the course of their employment, unless the employer has taken all reasonable steps to prevent the harassment from occurring. Employment tribunal time limits are increasing from 3 months to 6 months. The government recently laid Employment Tribunal recently laid regulations to extend the period of ACAS early conciliation as well. So that's going to increase from 6 weeks to 12 weeks from December of this year. And then finally, a tightening of existing tipping laws. So from October 2026, employers will have to consult with representatives about tips policies and review those policies once every 3 years at least. Then finally, 2027 is when we expect to see the changes for unfair dismissal coming into force. We will also see some changes around guaranteed hours and 0 hours working that will come into effect. There'll be some changes to collective redundancy consultation thresholds and when those are expected to kick in. Employers with more than 250 employees will be required to produce equality action plans that set out how they're going to address their gender pay gap. In terms of flexible working requests from 2027, a big change is that an employer will only be permitted to refuse flexible working requests for one of the 8 reasons that we are all familiar with, but they must also do so in a reasonable, they also have to consider the request in a reasonable way. So at the moment, there's only a requirement to think about to consider it. There's only a requirement to process the request in a reasonable manner. There isn't a requirement to make a reasonable decision, but that is changing in 2027. And then finally, there's going to be an introduction of a new right to unpaid bereavement leave for the death of a loved one and also in respect of pregnancy loss before 24 weeks. So the timeline is obviously, it's very ambitious and some of it has already slipped slightly with only 4 consultations having been launched this autumn, whereas I think it was originally the intention that 7 would be underway by now. Following the resignation of Angela Rayner, there was some suggestion that content of the ERB might be diluted. And if that does happen, it will be in the detail that's in the secondary legislation. However, the government appears to remain committed to implementing the ERB in full. And so businesses need to really be taking steps to prepare for these changes now, as there's clearly a very significant number that are coming down the track. If we could go on to the next slide, please. So unfair dismissal is perhaps one of the most notable areas of reform. The current 2-year qualifying period will be removed entirely. However, the government is consulting on a statutory probationary period to allow for proper assessment of an employee's suitability for their role. They're currently proposing a 9-month initial period, and in that 9-month probationary period, what we think will happen is that employers will be able to use a lighter touch dismissal process. And it may be the case that if they don't comply with that process, lower compensation might be awarded than would otherwise be the case. But a consultation on that is still to come. The initial probationary period or the light touch dismissal procedure won't apply to redundancy dismissals, presumably because they're no fault. So all employees from day one will have to be treated in the same way with regards to redundancy processes. If we could go on to the next slide, please. Fire and rehire is another quite significant area of change. So it's going to be automatically unfair to dismiss an employee because they've refused to agree to what's referred to as a restricted variation. So a restricted variation would be where an employer is proposing to make changes in relation to pay, pension, hours of work, bonus, and then dismisses an employee because they won't agree to that change. It's also automatically unfair to dismiss an employee to enable you to employ or engage another person who's going to carry out essentially the same duties, but they're going to do so under a varied contract. It will be a defence, though, to automatic unfair dismissal claims if the employer can establish that they couldn't reasonably avoid the variation and that the variation was necessary in order to significantly reduce financial difficulties affecting their ability to carry on the business as a going concern. That's quite a high bar, and so we think the exception is only going to apply in very limited circumstances. The pressures that are affecting the business have to be immediate, so there needs to be a degree of urgency there. I think it's essentially the case that the business would be facing solvency if the change were not made. The current code on dismissal and re-engagement is going to be updated, and failure to follow that new code without adequate reason is likely to result in compensation being increased by up to 25%. So when we take that together with changes to collective consultation, compensation for protective awards, the amounts of compensation that could be payable for employees where employers flout these rules could be really significant. If we could move on to the next slide, please. On collective redundancies, if an employer is currently proposing to make 20 or more employees redundant at one establishment within 90 days, then they must consult with appropriate representatives of the affected employees and give written notification to the Secretary of State. One change that's coming in from the 1st of December this year, which was only announced yesterday, is that there will be a new digital HR1 form. The original intention with changes to collective redundancy consultation was to remove the words "at one establishment," but that was abandoned because it would have meant that employers would have to collectively consult in situations where they were perhaps only making 1 or 2 redundancies at one site, 1 or 2 at another, and very quickly getting up to that 20 employee trigger point. So instead, what's going to happen is that a threshold will be based on the number of redundancies across the employing entity as a whole, which is likely to be, for example, 100 employees across the across the employer as a whole, or 10% of the whole workforce. But we're still waiting for exactly what that threshold will be. If we can move on to the next slide, please. Another key aspect of the bill is the new provisions relating to 0 hours and low hour contracts. Unfortunately, these provisions are really complex and we just don't have the time today to go through all of the detail, but there is some information available on the slide, and as Leslie said, we will be circulating a recording of the webinar. So if you are working in an industry that's likely to be affected by these reforms, you'll be able to read through some of the changes that are proposed. If we could just move on to the next slide, please. So finally, one of the areas that we're going to see significant change in is the trade union reforms, and a lot of these are coming into force quite quickly, either immediately when the ERB is passed or within 2 months of it being passed. So the first thing is that the requirement for certain sectors to operate minimum service levels during industrial action, which was introduced by the previous Conservative government, is being scrapped. So that will be gone, and then there is also going to be some strengthened protections against dismissals for employees that decide to take industrial action, and these changes will come into effect soon after the bill gets royal assent. So at the moment, where the reason or principal reason for a dismissal is that the employee has taken industrial action, the employer, there will only be an automatically unfair dismissal where the dismissal is taken place in close proximity to the employee having taken industrial action. But that time frame is going to be removed by the ERB, meaning that any dismissal, whether during the industrial action or at any point thereafter, will be automatically unfair if it's been motivated by the fact that the employee has participated in industrial action. The other provisions that are set out on this slide will be coming into force 2 months after royal assent. So we'll see restrictions that are introduced in relation to check-off in the public sector being repealed, making it easier for public sector employers to operate a check-off system. The requirement for certain public sector organisations to publish data relating to the use of time off for trade union duties and the ability to make regulations to limit that facility time off will be repealed. There's going to be additional requirements for unions, additional requirements for unions to supervise picketing are also going to be removed. And the notice period for industrial action is going to be reduced down from 14 days to 10 days. Originally 7 days was proposed, but 10 days has been decided upon following consultation. The details that have to be contained within a notice of industrial action are going to be simplified. And then finally, the period of validity for a mandate of industrial action is going to be extended for 6 months to 12 months, which will mean the trade unions have more time to act upon any mandate that they've received from their members to take industrial action. And I'm going to pass back over to Leslie now, who's going to talk about some of the practical steps that employers should be taking.
Thanks, Louise. So preparing for the imminent trade union changes should be the first step in your organisation's readiness for the ERB. I think it's fair to say that it will be more of a concern for some organisations than others, as the impact of the changes is going to vary according to the sector you're operating in, whether you recognise a trade union at present, the extent to which your workforce is unionised, and the relationship that you have with any trade unions at present. Some practical steps which all employers can take now include understanding and educating. Ensure that anyone within the business who has a need to know has knowledge of what the changes actually are and how they apply to your particular business. If you do recognise a trade union at present, recirculate the recognition agreement to key internal stakeholders to promote awareness of its terms. Consider training. Do any personnel, for instance, the HR team or line managers, need any training on existing and the reformed trade union rights and industrial action? Look at your guidance. Do you issue any guidance to line managers or other personnel who are routinely interacting with trade unions or dealing with employee relations issues? Does everyone understand what's expected of them when it comes to communicating with any recognised trade union and addressing employee relations issues? Do managers know what to do and perhaps more importantly, not what to do, what not to do when faced with industrial action? Foster good relations. The initial trade union reforms can't be viewed in a vacuum and are part of a more extensive bolstering of trade union rights. Even if the initial changes don't affect your business, the subsequent reforms will. Fostering a good relationship with any recognised trade union will make the changes easier to navigate and lessen the possibility of industrial action. Evaluate any existing relationships that you have, any points of conflict, and consider how these could potentially be resolved, if at all. Carefully consider your position on voluntary recognition if you believe that the reforms may make it more likely for the statutory procedure for recognition to be invoked, and of course, seek advice in appropriate cases. And finally, look at your staff engagement. Promote and maintain a positive relationship with staff to the extent you can, effectively and reasonably dealing with any employment relations issues as they arise. Improving or maintaining employee satisfaction may make trade union membership less attractive to individual workers, lessening the potential impact of the reforms. Evaluate your culture and current approach to employee relations. Can any improvements be made? Do any of your processes need to be more transparent? Does managerial adherence to key HR policies such as grievance and discipline need to be improved? You can't avoid the trade union reforms which are coming down the track, but you can take steps to make it less likely that non-unionised staff will be susceptible to approaches from trade unions seeking new members, and make it less likely that staff would support any industrial action proposed. Next slide, please. Further trade union related changes will come into effect in April 2026 and October 2027, as Louise has already touched upon. These are set out in detail on the slide. The new right to request access and the new requirement on employers to issue a written statement of trade union rights are slated to come into force in October 2026. I think it's fair to say that these are seismic changes which have the potential to revolutionise employee relations. The ERB sets out the basics of both new rights, with the finer details to be established in regulations which have yet to be drafted. In essence, a trade union will be able to issue an employer with an access request, which the employer must respond to. The parties will then negotiate the terms on which union officials are to have access. And if agreement cannot be reached, or if the employer hasn't responded to the request, an application may be made by the trade union to the Central Arbitration Committee for a determination on access. The purpose of the access requested can be meeting, representing, recruiting, or organising workers, or facilitating collective bargaining, but not organising industrial action. The access can be digital or physical, and the CAC will have the power to issue fines for any breaches of the right. Employers will be obliged to inform workers of their right to join a trade union at prescribed times during their employment. The penalties for a failure to comply are anticipated to be the same as those for failing to provide a statement of employment particulars, so 2 or 4 weeks' pay. The removal of the requirement for a minimum 50% turnout for valid industrial action ballots was originally going to come into force 2 months after the bill is passed, but this has been paused to align with the introduction of e-balloting. And as I mentioned at the outset, there has been a subsequent amendment in relation to when that actually will come into force. There's currently nothing in UK legislation which specifically prohibits an employer from subjecting workers to a detriment short of dismissal, because they are proposing to take part in or have taken part in lawful industrial action, and the ERB will plug that gap. Finally, the ERB will make it easier for a trade union to bring complaints of unfair practices during recognition applications and prevent mass recruitment into a bargaining unit to thwart recognition. Next step, please. So looking at these future TU reforms, what kind of preparatory steps can you be considering taking now? I would suggest that the starting point is risk assess. Risk assess the likelihood and impact of a trade union requesting access to your workforce. Is this likely to be positive, negative, or neutral? And how could any risks be mitigated? Then review. Review any existing recognition agreements and consider whether these remain fit for purpose in light of the reforms, or whether you should consider renegotiating these. And again, seek advice as appropriate. Maintain good relations. Continue to promote good relations with trade unions and with your workforce to lessen the likelihood of any disputes. Respond appropriately to correspondence. Address grievance and disciplinary matters reasonably and fairly, and regularly engage with staff. Consider taking the temperature of your staff with staff engagement surveys so that any unresolved issues which may prompt union involvement can be addressed. Understanding any perceived issues within the workforce gives you the opportunity to take steps to resolve these. Review and amend as needed existing processes to ensure compliance. For instance, your onboarding process, which in future will need to include a step relating to the provision of a written statement. Devise a new process which clearly sets out how requests for access should be dealt with. For instance, who has authority within the business to determine a request and who is responsible for submitting the response. And finally, train your team on the new requirements and your new and updated processes. For instance, how to recognise a request for access and what actions to take in response, and issue appropriate guidance. Next step, please. Thank you. Turning now to the April 2026 reforms and the preparatory steps which you can consider taking now to ready your business. Starting with audit. In light of the forthcoming SSP changes, audit your sickness absence levels and consider any short-term absence trends. Evaluate the likely impact of the SSP changes and, where appropriate, consider taking action to address individual cases of short-term persistent absence, bearing in mind any disability discrimination risks. Review and revise. Look at your contracts of employment and consider if any amendments are required in relation to SSP and paternity or parental leave entitlements. Then consider how best to approach any amendments. Review relevant policies and forms, updating and reissuing these as appropriate. That might include whistleblowing, sexual harassment, absence management, paternity and parental leave, and redundancy. Review any relevant processes in place, for instance, in respect of collective redundancies and sexual harassment complaints, and consider whether any improvements are required. Communicate the changes to all those within the business who have a need to know. And I would suggest that, as a minimum, are those managing absence and making strategic decisions on redundancies. Reissue revised paternity and parental leave policies. Consider refresh training on managing sickness absence, dealing with sexual harassment complaints, and collective redundancy exercises. And then forecast. Look ahead. Are any redundancy, restructuring, or changes to terms and conditions exercises envisaged? If so, consider adjusting budgets in light of the increased financial exposure for protective awards and carefully review the timing. Next slide, please. I'll briefly touch on the consultations which we have ongoing. If we can move to the next slide. Thank you. So 4 consultations were launched on the 23rd of October this year. Firstly, in respect of the duty to inform workers of their right to join a trade union, this consultation closes on the 18th of December. The government proposes that the notification to workers includes a brief factual description of the function of a trade union, a summary of the statutory rights afforded to trade union members, a list of trade unions recognised by the employer, if any, and a signpost to a government webpage which would contain a list of trade unions. There's 2 options being considered for the format of that statement, with the government preferring a standard form, which would be templated by the government. The government's preference is for the statement to be delivered directly to new workers, along with their Section 1 statement, as opposed to it being provided indirectly, which would be pinned on a notice board or on an intranet. For existing workers, various options are being consulted upon, and the government's preference is that employers would be able to provide the statement to their existing workforce, either directly or indirectly. So, for instance, in a handbook or on the intranet. And if it is to be provided indirectly, it would have to be continuously available, and the employer must ensure that workers had reasonable access to it. On frequency, the options subject to consultation are the statement being provided every 6 months, annually, or sector specific, with the government leaning towards annually. The second consultation relates to the right of trade unions to access workplaces. Again, this is open until the 18th of December this year, and it's covering off how unions will request access and how employers will respond, applicable time limits, the factors the CAC will take into account when deciding whether access should be granted and on what terms. And here, it's notable that the government is proposing an exemption for employers having less than 21 workers, and also in terms of fines, how the CAC should assess fines. The government will set the maximum fine and favours a 2-stage approach of £75,000 for an initial breach and up to £150,000 for repeated breaches. A consultation on bereavement leave, which is the new right to unpaid bereavement leave for the death of a loved one or pregnancy loss before 24 weeks, has also been launched. And that's seeking views on the eligibility criteria for it. For instance, in pregnancy cases, should the time off be limited to the person who's physically experienced the loss, or should it be wider? The types of pregnancy loss that ought to be covered, and the government has suggested what it thinks should be covered. when and how the leave should be taken, and the notice and evidential requirements to be applied. The fourth and final consultation that we have open just now is in relation to the enhanced dismissal protections for pregnant workers and new mothers. And there's broadly two options for how this would operate. The first option is to retain the existing fair reasons for dismissal, conduct, capability, etc., but to introduce a higher test of fairness when an employer is relying upon that fair reason to dismiss. And examples for that higher test include that continuing to employ the woman would have a significant detrimental impact on the business, or that they pose a health and safety risk. Or the second option is to narrow the scope of, or actually remove some of the fair reasons, so that these could not be relied upon to justify the dismissal of a pregnant worker or new mother. So, for instance, narrowing the conduct reason so that it would only apply in the case of gross misconduct, or narrowing redundancy so that it would only apply for dismissals of new mothers and pregnant workers if the business was in significant financial difficulties. And this is something akin to the fire and rehire exception. So those are the options under consultation. It's also looking at whether the protection should be a day one right, or whether there should be a short qualifying period, when the protection should actually start and end, and whether enhanced protections should be limited to pregnant workers and new mothers, or whether it should be expanded to include those who have taken other types of statutory family leave. Next slide, please. We still have some consultations to come. They are set out on the slide. And I would mention at this point, we do have our Employment Rights Bill hub on the Brodie's website, so you can keep track. And then our final slide, please. Just a quick word on Workbox by Brodie's, which is our award-winning HR and employment law site, which contains more than 350 guidance pages and over 250 templates. And it provides pragmatic, comprehensive guidance on a breadth of employment law issues, and it's written by our experienced lawyers, including myself. And if you would like to arrange a complimentary demonstration or trial, don't hesitate to contact us. Now, and otherwise, we do hope you found this useful, and thank you very much for your time and attention today.